Welcome to this AI debate on cancel culture, accountability, or mob justice, where chatbots explore both sides. We'll begin with opening statements from accountability and mob justice. Now, accountability.
Imagine a company changing its harassment policy, an organization launching an independent investigation, and a lawmaker sponsoring a reform bill, all prompted by public pressure and grassroots campaigns rather than courtroom rulings. I am arguing that what critics label cancel culture is in many important cases a form of essential social accountability, a non-state mechanism that democratizes consequences when formal institutions fail to protect the vulnerable. Investigative journalism and public testimony have a long history of exposing abuses that were hidden or tolerated for years, and the revelations that catalyzed the MeToo movement are a vivid example of that dynamic. When survivors and reporters made systemic patterns visible, institutions that had long ignored complaints were suddenly forced to confront them. That is accountability, not spectacle. Public pressure gave voice to people who had been silenced by power, confidentiality agreements, and institutional indifference. Those voices did not just register outrage, they created a sustained narrative that compelled actors across sectors, from private firms to membership organizations and legislatures, to reckon with problems they had minimized or dismissed for decades. When employees organized and went public, as they did in global walkouts over workplace misconduct and a culture that protected perpetrators, companies responded with internal investigations and policy revisions. Those responses were not handouts from the state. They were consequences delivered by publics, consumers, and coworkers, exercising social and economic influence. The practical results matter. High-profile firings and resignations, corporate policy rewrites, and the opening of independent inquiries demonstrate that social sanctions can produce concrete institutional change rather than merely symbolic outrage. Evidence collected in the workplace shows that after sustained public attention, many organizations revisited harassment policies, improved reporting channels, and invested in training and accountability measures. Those institutional shifts often included clearer disciplinary paths, stronger non-retaliation protections, and commitments to monitoring and public reporting, steps that change future behavior as well as correct past wrongs. That matters because formal legal remedies are often slow, costly, and inaccessible, especially for marginalized people. The practical obstacles, the time and expense of litigation, the emotional toll of public court battles, and the risk of professional retaliation mean many victims never see a legal resolution. Social accountability democratizes consequences by lowering the barrier to collective response. It enables communities directly harmed to name wrongdoing and demand repair when regulators, courts, or employers do not act. Economic and reputational sanctions, boycotts, calls for professional consequences, withdrawal of endorsements, can create incentives for corporations and institutions to change behavior without invoking state coercion. Those incentives have led not only to personnel changes but to negotiated remedies, public apologies, settlement terms that include policy commitments, and independent reviews that otherwise would not have occurred. In some cases, the pressure produced concrete bargaining power. Organizations agreed to fund independent audits, to adopt new complaint procedures, or to support survivor-centric remedies as part of settlement terms. Beyond discrete outcomes, public accountability shifts cultural norms. When harmful behaviors are exposed and widely discussed, what was once tolerated becomes stigmatized. Expectations of acceptable conduct evolve. That normative shift deters repeat harms by changing what communities and workplaces will tolerate and by giving future victims language and precedent to speak out. Over time, those shifts make it easier for bystanders to intervene, for employers to act decisively, and for victims to access remedies without bearing the entire burden of proof or risk. To be clear, I do not celebrate online excesses or endorse indiscriminate shaming. Genuine accountability requires guardrails. Proportionality, so responses fit the harm, transparency, so facts are not manufactured, opportunities for correction and apology, and restorative options that prioritize repair over pure punishment. Distinguishing legitimate social sanction from mob justice is a practical task, not a reason to reject public accountability wholesale. We should refine norms and practices, encouraging verified reporting, protecting due process where possible, and supporting community-led restorative measures, rather than retreating into a false choice between silencing victims and allowing viral vigilantism. Practical reforms might include clearer community standards for verification, mechanisms for independent fact-finding, and structured avenues for apology and restitution that create incentives for accountability without permanent ostracism. Critics often frame this as a free speech problem, but freedom of speech protects the right to speak. It does not shield individuals or institutions from social consequences of their speech or conduct. The relevant question is not whether people can speak, but whether society will tolerate harms without consequence. The answer should not be no consequence. Finally, we must acknowledge limits and abuses within social sanctioning and design remedies, mechanisms for contesting false allegations, platforms for nuance, and community standards that favor repair and reintegration when appropriate. Those reforms make public accountability more just and more sustainable. In short, public accountability is an imperfect but indispensable tool for correcting power imbalances and enforcing norms when formal institutions fail. Our work today should be to sharpen its principles and safeguards so that it amplifies marginalized voices, channels pressure toward constructive change, and enables repair, not to abandon the capacity of communities to demand justice.
Now, mob justice.
There is a principle that has guided Western justice for centuries. It is better that 10 guilty persons escape than that one innocent suffer. Today, a single, unverified post can reverse that priority in public life. Rapid, social media-driven punishments routinely bypass basic procedural safeguards, producing disproportionate and sometimes permanent harms to reputation and livelihood. Evidence shows that false or misleading claims travel faster and farther online than accurate information, which creates a system that privileges speed of condemnation over careful fact-finding. Surveys of online experiences confirm a climate in which harassment, threats, and public humiliation follow almost instantly from a viral allegation, and many targeted people report withdrawing from public life as a consequence. These are not abstract complaints, they are predictable outcomes of platform dynamics. The architecture of social media makes virality the currency, and virality rewards outrage, not verification. When incentives favor shares and reactions above context, mistakes multiply, and retractions rarely repair the damage. Public shaming that begins on a timeline and spikes within hours can end careers and erase years of work in days, with little chance for appeal or nuance. Cases recounted in modern narratives of public shaming show how quickly context is lost and how long reputational wounds can persist. The online mob has no formal rules of evidence, no impartial adjudicator, and no appeals court. It has only momentum. The combination of anonymity, rapid amplification, and reward structures for outrage creates a structural bias toward immediate condemnation rather than investigation. Anonymity lowers barriers to piling on, virality amplifies the loudest takes, and platform algorithms magnify content that provokes strong emotional responses, and so the crowd's judgment substitutes for careful institutional processes. That substitution matters because institutions like courts, human resources departments, and professional bodies exist precisely to balance rights and responsibilities through procedures that protect the innocent, measure proportionality, and allow remediation. When we replace those institutions with viral punishment, we erode presumption of innocence, eliminate proportional responses, and close off pathways to rehabilitation. The result is a justice that is extrajudicial in every meaningful sense, fast, anonymous, unforgiving, and often irreversible. These dynamics also create chilling effects across society. Evidence shows that people, especially academics, journalists, and professionals, self-censor to avoid the risk of viral reprisals, and that worry about online consequences narrows the range of permissible inquiry. When faculty alter syllabuses, researchers avoid controversial topics, or reporters decline lines of questioning because a single misstep could provoke a social media storm, our civic conversation suffers and our institutions grow timid. This is not only a theoretical loss of speech, it has documented mental health consequences for those targeted and for communities watching the spectacle unfold. Reports link social media harassment to anxiety, depression, and other harms, particularly for young people exposed to persistent public shaming. You cannot defend a healthy public square while tolerating a system that produces measurable psychological damage as a byproduct of punishment. My opponent will say that cancellation is necessary accountability and that it empowers marginalized voices who lack institutional recourse. I agree that marginalized people deserve power and protection, but the question is by what mechanisms? Relying on unregulated mobs to adjudicate complex disputes trades accountable remedies for unpredictable punishments. Accountability performed through transparent investigations, clear standards, impartial adjudicators, and avenues for appeal preserves both redress and rights. Mob-driven punishment preserves only retribution. We should demand stronger institutions that can act swiftly when warranted, but also fairly. Timely investigations, proportional discipline, restorative practices, and publicly accountable outcomes that allow for correction and rehabilitation. That balance protects victims, preserves due process, and prevents the irreversible ruin of mistakes, satire, or private views taken without context. To be clear, this is not a defense of wrongdoing or of shielding those with real power from consequences. It is a plea for procedure, proportionality, and humanity. If our aim is a just and accountable society, the remedy must be rights-focused reform, not the unpredictable, anonymous, and irrevocable punishments meted out by online mobs. Restore accountable processes for adjudication, require transparent standards from institutions and platforms, and prioritize remedies that allow truth, repair, and rehabilitation instead of permanent public condemnation. That is how we deliver both justice and the conditions for free inquiry. Anything less is mob justice masquerading as accountability.
Now, let's hear the first rebuttals from accountability and mob justice. Now, accountability.
I'll accept the moral center of the other side's claim up front. Procedures, proportionality, and the possibility of rehabilitation matter. Those are not luxuries. They're essential to a just society. Now, the practical question we must face is this. Which systems reliably deliver timely, meaningful remedies for people who lack money, status, or institutional leverage? When a workplace protects a powerful harasser, when internal reports disappear into confidentiality, when regulators decline to investigate, the theoretical ideal of due process doesn't help the person who is harmed today. In those gaps, public pressure often becomes the only lever available. My opponent warns about viral misjudgments, irreversible reputational harm, and chilling effects. Those are real dangers, and I don't minimize them. But the correct response to excess is not to abandon collective consequences entirely. It is to improve how we do collective consequences. We can and should insist on proportionality, on centering corroboration rather than rumor, on timelines that give institutions a chance to act, and on community-led restorative pathways that allow apology and repair. Those are guardrails, not repudiations, of social accountability. Second, we should distinguish the flash mob pile-on from sustained, evidence-driven public campaigns. There is a difference between a single unverified post that explodes for clicks and a pattern of reporting, survivor testimony, and sustained civic pressure that produces independent investigations, policy changes, resignations, or legislative follow-up. The latter is not mob justice so much as civic enforcement when official mechanisms fail. Third, on the chilling effects argument, I hear the concern that people self-censor. The remedy is not to neuter consequences for misconduct. It is to make accountability processes more transparent and fair so that people trust them. That means public standards for corroboration in high-stakes cases, independent audits of institutional responses, whistleblower protections, and clear pathways to rehabilitation after wrongdoing is addressed. Finally, ask yourself which side better protects the vulnerable now. If the alternative to social sanction is silence, invisibility, or private settlements that protect offenders, then refusing collective accountability leaves power imbalances intact. Yes, mistakes happen. Yes, social pressure can be excessive. But the right project is refinement. Design proportional, transparent, restorative public accountability, not a reflexive defense of wrongdoers because the crowd sometimes errs. I concede excess exists. I insist we fix it by building better norms and institutions that work with, not against, community-driven accountability. That is how we deliver both justice and dignity for people who have been left out by the formal system.
Now, mob justice.
I agree with the core moral point my opponent makes. Public pressure has exposed real wrongdoing and compelled institutions to act when they otherwise would not. That concession matters because it frames the debate correctly. The question is not whether to hold people and institutions accountable, but how we do so without allowing anonymous, instantaneous crowd verdicts to replace fair procedures. Their strongest evidence is the power of immediacy. When communities amplify a claim, institutions often respond. But immediacy is a double-edged sword. The same dynamics that surface long-hidden abuse also amplify errors, reward punishment before verification, and make context invisible. Imagine a courtroom in which the jury delivers a sentence based on the first whisper they hear before the defense can present witnesses or documents. That is a fair analogy for how virality often operates online. Speed becomes its own evidentiary standard, and speed favors certainty, even when certainty is mistaken. Second, my opponent points correctly to institutional change prompted by public attention, but they leave out how often that attention produces disproportionate, lasting harm to individuals without investigation, remediation, or a path to redress. Careers and reputations can be destroyed by ambiguous old posts, satire misread out of context, or false attributions long before anyone has bothered to check the basic facts. Third, they celebrate democratized sanctions while overlooking the chilling cost. When academics, journalists, and professionals see colleagues punished in the court of public opinion with no procedural safeguards, many choose silence. Inquiry narrows, debate impoverishes, and institutions lose the very scrutiny that keeps them honest. Their claim that social sanction democratizes consequences also begs a structural question. Who guarantees fairness for the accused when sanctions are delivered by an anonymous, incentive-driven crowd? Unlike courts, professional boards, or human resources processes, internet mobs lack clear standards, appeal paths, and proportionality. If we accept their premise that public consequences are sometimes necessary, we must insist on accountable procedures. That means rapid but transparent fact-finding mechanisms, provisional measures tied to explicit timelines, clearly defined standards of evidence, meaningful appeal rights, and restorative options that prioritize repair and reintegration. It means rethinking platform design to slow amplification just long enough for verification, and bolstering institutional channels so that marginalized voices can seek redress without forcing an all-or-nothing viral campaign. The values at stake are familiar: presumption of innocence, proportionality, due process, and the possibility of rehabilitation. We can have accountability and preserve those values, or we can trade rights for speed and call the result justice. I urge the audience to choose institutions and procedures over rumor and permanence.
Moving on to the second rebuttals. Now, accountability.
I agree with the moral core my opponent just reiterated. Procedures, proportionality, and the possibility of rehabilitation matter. That shared ground is where we should build, not dig trenches. But the practical choice before us is not between flawless courts and chaotic mobs. It's between systems that actually deliver remedies and the status quo that too often protects the powerful. Which institutions, my opponent must answer, reliably provide timely, accessible relief to an employee whose internal complaint disappears into a confidentiality clause, to a student whose university dismisses complaints to preserve donors, or to a tenant whose landlord retaliates when they report abuse? When formal channels are inert, public pressure is the only lever left for people without wealth or influence. Ask not whether social consequences sometimes err, they do, but whether the alternative is silence, invisibility, and ongoing harm. Their vivid images of viral, mistaken punishment are real dangers and deserve respect. But the correct response to those dangers is not to reject public accountability. It is to build guardrails that channel civic energy toward fair, proportional outcomes. That means 3 practical reforms. First, establish public standards for corroboration in high-stakes allegations, so amplification favors verified patterns over one-off rumors. Second, Require transparent timelines and independent audits for institutional responses, so public pressure prompts accountable investigations rather than summary ruin. Third, create community-centered restorative pathways, calibrated sanctions paired with opportunities for apology, reparation, and monitored reintegration. These are not utopian fantasies. They are design principles that preserve both responsibility and mercy. If my opponent insists that the mere possibility of error invalidates social sanction, then they must show what concrete alternatives they supported when victims were silenced. Faster investigations, legal aid, whistleblower protections, accessible ombuds offices, and demonstrate those actually worked better than civic pressure. Otherwise, their defense of procedural purity becomes a defense of the privileged who can wait on slow institutions while others suffer. Finally, let's be honest about goals. Do we want a society where norms against harassment, discrimination, and corruption are enforceable by communities, or one in which those norms exist only on paper and behind closed doors? The project I defend is not mob rule. It is accountable public enforcement refined by standards of proportionality, transparency, and restorative repair. In my closing, I will show how we keep the power of civic response while minimizing harm by institutionalizing the very safeguards my opponent rightly demands. The choice is not between chaos and courts. It is whether we design public accountability that is fair, effective, and restorative.
Now, mob justice.
You are right to insist that procedures, proportionality, and the possibility of rehabilitation matter. I accept that concession because it lets us focus on the real question. How do we hold wrongdoers to account without turning rumor into a permanent sentence? My opponent insists that public pressure is often the only lever for the powerless, and I agree that social scrutiny has catalyzed necessary reforms. That agreement is precisely why we must be careful about method. There are three structural faults in treating viral outrage as a primary accountability system. First, speed becomes a proxy for truth online. Virality rewards certainty and punishes nuance, which means that unverified or decontextualized claims can metastasize before anyone has the chance to verify facts. When reputations are erased in the first 48 hours, errors are not corrected by subsequent reporting. They are fossilized. Second, the system lacks proportionality and remediation. Public shaming routinely converts mistakes, satire, or old ambiguous statements into career-ending verdicts with no clear path back. Institutions that do adjudication, courts, HR processes, licensing boards, exist because measuring culpability and fitting punishment to offense is hard work that requires evidence, cross-examination, and appeal. A crowd organized by outrage lacks those mechanisms. Third, there is a chilling cost to inquiry. When academics, journalists, and employees watch peers punished in the court of public opinion without procedure, they narrow their questions and avoid controversial but important lines of inquiry. That loss of intellectual risk harms everyone, especially the marginalized groups whose causes depend on robust, investigatory journalism and scholarship. My opponent proposes better norms and community-led restorative pathways, which is exactly the right direction. But those are solutions that work only if they are institutionalized. The question is not whether collective consequence has power, it is who wields that power, under what standards, and with what checks. So here is a practical, reform-minded alternative. Preserve the advantages of public scrutiny while redirecting its force into accountable channels. That means rapid but transparent fact-finding teams, provisional measures that expire unless substantiated, meaningful appeal rights, restorative options focused on repair and reintegration, and platform design changes that slow amplification long enough for verification. It also means building trusted avenues for marginalized complainants to bring claims without needing to weaponize virality. The values test is simple. Do we prefer a system where rumor and permanence are the default, or one where accountability is coupled with proportionality, due process, and the possibility of rehabilitation? If we care about rights as much as remedies, the answer is clear. The task now is to design institutions and platform norms that channel civic energy toward fair outcomes, not to celebrate spectacle as a substitute for justice.
Finally, the closing statements from both sides. Now, accountability.
We began this debate agreeing on one thing: procedures, proportionality and the possibility of repair matter. Hold that truth in your mind as we decide what comes next. What critics call cancel culture often functions as a civic correction when courts, regulators, and employers look away. Survivors telling their stories, journalists exposing patterns, consumers refusing to fund abuse. Those pressures have produced stronger harassment policies, independent investigations, resignations that cleared the path for reform, and corporate changes that made workplaces safer. That is accountability, not chaos. Yes, online excesses happen. Yes, reputations can be damaged unfairly. The right response is not to abandon public accountability, but to strengthen its guardrails. Insist on proportionality, on transparency about claims, on pathways for apology and rehabilitation, and on community-led restorative practices. If we value justice, we should refine how society responds, ensuring consequences serve repair and deterrence, not vindictiveness. In short, reject mobbing, embrace accountable public conscience.
Now, mob justice.
When a single unverified post can erase a career, we have to call that what it is: extrajudicial mob justice, masquerading as accountability. We've seen how rapid social media punishments strip away context, ignore proportionality, and leave no room for investigation, appeal, or rehabilitation, turning mistakes, satire, or private views into permanent sentences. The mechanics matter. Anonymity, virality, and reward structures favor punishment over truth and conformity over inquiry. My opponent is right that public pressure has sometimes forced institutions to act. I agree accountability matters. But democracy and dignity are not served by shortcuts. Real accountability requires procedures, fair investigations, transparent standards, the presumption of innocence, proportional discipline, and opportunities for repair. That is how we protect vulnerable voices without weaponizing the crowd. If we value justice, we should strengthen institutions that adjudicate responsibly, not outsource punishment to the feed. Justice needs due process. Outrage without it is cruelty, not remedy.